We're
Hi,
going.
welcome everyone.
I think we have to get everyone in from the waiting room.
Oh, okay. See a lot of people from Gray Robinson here, Ron. You got a fan club.
Ah,
Including my old buddy John Boudet.
and we got the green light to go ahead from Michelle. So we can go ahead and start, Bridget.
Welcome everyone. Thank you so much for being with us today. Judge Curley and Judge Schulman have put together a fantastic presentation. First, I want to thank the Palm Beach County Bar Association for once again hosting this town hall. And I want to let everyone know that, again, the bar is being very proactive and cooperative in making the presentation that Judge Schulman has put together. The PowerPoint presentation will be available on the bar's website. And there will, as I understand it, they are also trying to make available the recorded presentation. First, I'd also like to thank Ron Panzoli and also Lauren Johnson, who are the co-chairs of the Judicial Relations Committee of the Palm Beach County Bar Association. Thank you for putting this together. My name is Bridget Berry. I am on the CLE committee of the Judicial Relations Committee, and I'm with Greenberg Traurig. Ron, did you want to say a few words about Gray Robinson?
Oh, I'm I'm with Gray Robinson. We're excited about today's presentation and looking forward to being a continued discussion in this space on the rule changes.
And we'd also like to thank Michelle Gale from the Palm Beach County Bar Association for being amazingly helpful in getting this all together. Judge Curley is the administrative judge for Circuit Civil, and he was with Gunster for many, many years. I have to mention Notre Dame. Go Irish, great
That's
year. And then a graduate of Stetson. And then Judge Schulman is the chief administrative judge for County Civil, University of Florida, and then Georgetown Law. And Judge Schulman practiced also at a larger firm, Still Hector, and also was the South Florida bureau chief for help me out here, Judge Schulman.
Florida Attorney General's office.
Florida Attorney General's office. Thank you so much. And may I pass it on now to you, Judge Schulman.
All right, I'm actually going to turn it over to Judge Curley, who thank you so much for Judge Curley's work on this and in part one. And I'm sharing my screen now.
Okay. All right. Good afternoon, everybody. It's a pleasure for us to do this. Let me say a couple things before I jump into the content here. First of all, as many of you know, we did a town hall number one. Town hall number one was the rule changes up to December. Town hall number one, the PowerPoint materials are available. There's a YouTube where you can watch it if you haven't had an opportunity to watch it. It is available through the bar's website. I would encourage everybody to do that if you haven't done it already. One of the benefits from doing that is there's a red line version that will show you the exact changes of the rules. And of course, we do our best to walk you through that. So without repeating that today, because that's not our plan today. Our plan today is to cover the recent rule changes. By that, I mean since we last did that. And primarily that's going to relate to things like summary judgments and the timing of summary judgments. Some of the discovery rules have changed, and we're going to walk you through that today's talk is more from a practical standpoint. By that, I mean some of the takeaways that will help you as you use these rules and go forward.
And
We met.
Judge Curley, if I could interrupt for 1 minute, I apologize. And for those of you all who have questions, the chat room is disabled. Please send them into the Q&A. I will track them and we will push them out to the judges as the time allows. Thank you.
Okay, thank you, Ron. Ron's going to hit me with your questions when he's ready and will do his very best to catch me off guard. Is that correct, Ron?
That is the plan.
Okay.
The entire session.
Okay, but we will do our best to answer your questions. The goal today is to give you the takeaways on how to use these rules. And what I was going to say is we met yesterday, Judge Schulman and I, with the judges here in Palm Beach County, the Civil Circuit and county judges. We met yesterday and went through a very similar presentation with them, got some feedback on their observations and their takeaways, which we'll try and give you as we go through today. So without further ado, let's dig into it. You see the, go back one more slide there. You can see all the rule changes. We're going to cover some of those, but you can see all the rule changes there that we're going to address. What I want to say about those without digging too deep, the guide, the manual for you all, if you look at the DCMO orders that are being issued now, and also the administrative order 3.110, you see that at the bottom of the agenda there. If you read through those, and hopefully you have by now, but if you haven't, do so quickly. It'll walk you through exactly what's happening here in Palm Beach County when the case management orders are issued. It'll tell you how to do a number of things that are required under the new rules, and that will help you maybe more than anything else that we're going to do. That's going to help you to implement these things. So, okay, let's jump into the next slide then. Affirmative defenses, this is an easy one, quick change, but it just echoes the case law that most of you, probably all of you already know. And you can see there in the red line, a pleading that sets forth an affirmative defense must contain a short and plain statement of ultimate facts supporting the avoidance or affirmative defense. My knee-jerk reaction was to not even bother with this slide, but there is a point to be made from it. And here it is. Heretofore, when you had affirmative defenses like mitigation as an example, or let's say your Fabre defense, and you allege those at the outset of the case, you had no facts to support it most of the time. And motions to strike, personally, I would deny those. Why did I deny those? Because later on it would keep the case from being at issue. It would delay the case, delay the progress of the case. What I would say is you can add, you can come back on summary judgment, or you can move to strike later and we'll deal with it after they've had an opportunity to do discovery. What's the difference now? No more at issue rule, folks, as you all know. So now you can amend later in the game. I'll let you amend later in the game because the case is going to stay on the trial docket. Things are going to progress. And by that time, if you have a mitigation defense, if you have a Fabre defense, then you'll have the facts to go with it and you can comply with this. That's the point, that the little takeaway for you from that. Next slide. Okay, Rule 1.200, the case management rule. As we all know by now, Rule 1.200 starts off with subparts A through D with the exemptions and the requirements of a designation of a track and the issuance of a case management order. Circuit civil cases are most likely to see the exemption for expedited treatment based on a party's age. It's not specifically listed, but it's referenced. Elderly folks are entitled to expedited treatment. That's an exemption that you all can ask for. The reason I mentioned it is because the clerk's office will catch a lot of these exemptions. When you file your case, they're going to catch some of these exemptions and they'll treat it immediately. Some they will not, like the age of the litigants. The DCMO order tells you exactly how to handle that and how to deal with that so that you can get expedited treatment if that's what you're seeking. But there are 18 categories of exemptions. They're all listed. The case management order is going to issue within 120 days of filing here in Palm Beach County. They're going to issue it when the case is filed. So the day the case is filed, the case management order, the DCMO will be issued. Let me say this before we go further. Before, under the old rules, I'll just call them the old rules, cases, the progress of a case was lawyer managed. You all monitored the progress of the case. You filed the case when you were ready. You served the case when you could. You took discovery when it fit your schedule. You filed your summary judgment if you were going to file summary judgment when it was convenient for the parties. And when you were ready for your trial, you'd file a notice that the case was at issue and a trial order would be issued. Under the new rules, the new Supreme Court mandate, that's gone. What we have now is the DCMO, which is going to set your deadlines. It's going to set a case management order. It's going to require service within a certain period of time. It's going to require initial discovery. It's going to require supplemental discovery. We'll get into all that. The judge's role, our role going forward is to monitor those things, to make sure that to the best of our ability that you all are keeping up with the requirements. And if you need assistance, we'll be here for that. So during the course of our presentation today, we're going to talk about how you do that. What I want to emphasize, this is new for most of the judges. I practiced mostly in federal court before I became a judge. That's how they were doing it, but it's new for the judges as well. Our goal isn't to be the heavy here. Our goal isn't to be the person sanctioning someone for non-compliance. Our goal is to make sure that the requirements are met. Part of today's presentation is to help you all understand how to meet those deadlines, and if you're having trouble meeting them, how we can help intervene if it's done in the right manner and in the manner that we set up. We're going to do our best to make sure that everybody understands the rules and can meet these requirements. That helps us. That'll help you guys. That's our goal in this meeting. That'll be our goal going forward. We know there's a learning curve here, but the Supreme Court has been very clear, as you'll see, about our mandate and yours. Next slide. Track changes, 1.200. Track changes can occur, but they're not a substitute for a continuance. In other words, as an example, you go from a streamlined case, which is 12 months. That's what the projection is, to a general track, which is 18 months. The thought may be, well, we'll just change the track and we'll go from streamlined to general so we get an extra 6 months. That's treated under these rules, and our mandate is to treat it as a motion for a continuance. So that has to be done in the same manner that a continuance would be filed. So if you're asking to change the tracks from an example, non-jury to a jury case, then there'll be an issue about whether it's a continuance right off the bat. The good news is the DCMO orders tell you exactly how to do that, exactly what you do in order to change those tracks. So it's there for you, but we're going to talk in detail about what requires a continuance and what just requires an extension or a change of deadlines, which should be hopefully relatively easy. Next slide. And here you have the administrative order 3.110, which has a lot of directions for you. As you can see, if you haven't read the administrative order issued by Judge Kelly, I think it was at the end of December, it's there for you. Here's the tracks. General track streamline. And it basically runs from 18 to 12 months. There's also complicated cases, which are matters which are 30 months. But in order, as we'll see in a little bit, in order to get that treatment, you have to go through a process. This is all part of the administrative order. It tells you how to change the track designations. All you have to do is read it and follow it, and it'll walk you through it step by step. Okay, next slide. Here's the uniform differentiated case management order and order setting trial. Couple things to bring to your attention. You'll see a couple things that are a little bit unique for those of you who are practicing in other circuits. We're setting an actual trial date here. So your actual trial will be set. What does that mean? When the case is filed, you're going to get a trial calendaring date. That's an actual trial calendaring date for purposes of scheduling. And what does that mean in the long run? If there was just a projected trial date, then there'd be other steps that you need to take. Those steps are not necessary with this form of order. Okay. Here are some of the mandates required by Rule 1.200. You can go, yeah, there you go. These are all included within our order. Service of the complaint, service under extensions, et cetera, et cetera. Do you have the layover, Judge Schulman? Let's see, next slide. There it is. That's part of for those of you who haven't seen the case management orders that are being issued automatically now, this is how they look. And these orders have the deadlines, and they're automatically produced by the clerk's office. And you'll get these when you file the complaint, and they're served with the complaint on the defendant. Some of the important suggestions we would have for this: make sure those of you who work closely with legal assistants, I'd involve them closely in this process. Make sure they're aware of the system, that they're calendaring the dates for you. These are court-ordered deadlines. They're not suggested deadlines. As you'll see in the rules that we'll look at in a few minutes, these are must complies. They're not guidelines or suggestions for when to comply. Couple of things that we have in our rules that you can see here as an example. If you look at number 11 there, file and serve motions for summary judgment and Daubert motions. Those are deadlines that are built into our order. Some of these deadlines are not mandatory. They're just suggestions to put in your case management order. We took those suggestions and included them so that you would have guidance on these things. Okay, next slide.
All right, so now we're going to talk about extensions. And as Judge Curley said, before they were suggestions, now that you have these DCMO trial orders, now they are court ordered. So how do you change a court ordered deadline? First, look at the rule. And throughout this presentation, we have snippets of the Supreme Court's opinion. There's two of them that we're talking about mostly today. I have found that version to be the most helpful because you can see what has been stricken and what has been added. That really calls out to me what the new changes are versus just going on Westlaw and looking at the rule in a vacuum. So for example, strict enforcement of deadlines. And by the way, what we're showing you today is the December amendments, which are amendments to even what was done in May. All right. So these already presuppose the May amendments. Let's talk first about the fact that the new rules are requiring judges to strictly enforce these deadlines. So if you look at this new rule 1.200 D and E, two times in one page, the word strictly enforced or strict enforcement is included. They're really serious about this. And as Judge Curley said, we're not looking to be the taskmasters, but we are definitely required to enforce these. So the goal and the discussion today is how can we work together and have a conversation about your cases as we go along throughout the life of the case so that you're in compliance and we don't have to be the bad guys. But the point here is we all are in this boat of strict enforcement of deadlines.
Judge
So
Schulman,
now, yes,
before
sir.
you, before you go there, can I say one other thing about
Always.
that? Yeah, a lot of the rule changes suggest cases like Banger are no longer applicable. That would be my read for the most part. It's not quite gone, but Banger and those cases and its progeny may be a thing of the past. And as Judge Schulman said, and she's going to tell you about the key with the changes here, it isn't that you can't get extensions and things like that. You can, and there's a process for it that she's going to show you about. But you have to get ahead of this. You have to ask for things like extensions in advance. You have to work within the system so that the judges that are involved in your case, Judge Schulman or me or any other judges, rather than coming to them after you've already blown deadlines and gotten behind the schedule, come to them in advance so that they're prepared, they're aware of the progress of your case, they're aware of the issues, and there's a process for that. The Judge Schulman's going to walk you through. That's it.
And 100% talk to
And-
us. Talk to us early in your cases. And I can hear all the registrants saying, that's great. What do I do if I can't get a hearing? We are going to address that. Stay tuned. Don't go anywhere.
Judge Schulman, there's two questions that have come in that fit well with what you're going to be talking about. So if you could address them as you go through your presentation on these extensions and enlargements of time. One is concerns about being able to withdraw from a case and how the tighter rules in terms of extensions and continuances may impact an attorney's ability to withdraw and how an attorney should address that. And then one of the issues we saw before this presentation is vacations. Questions are still coming in about vacations and how they fit that into continuances.
These are all good practical questions, and the judges are aware of these issues because we've all been lawyers before and we hear from this. So let's talk about this. Let me, if you don't mind, get out the first couple of slides because then I'm going to tie it into those questions. So there's two types of extensions. There are, and I'm going to make a note, vacations and withdrawals. All right, there's two types of extensions. There's an extension of a deadline, and then there's continuing the trial. And right off the bat, please remember these are two very distinct, different things. First, we're going to focus on pretrial deadlines under 1.200E. So right off the bat, E1 tells you you can submit an agreed order to extend a deadline if the extension does not affect the ability to comply with dates down the line. What does that say? These are a lot of words. Here's what I say, stop. All right. If you need to modify a deadline, and let's play in here the vacation. The second you know you've got a vacation coming up, you need to modify a deadline because you're not going to be here when that motion is due or the discovery closure is. Ask yourself, if I ask for an extension of this particular deadline, will it affect the ability to comply with all remaining downstream deadlines? If the answer is no, you can upload an agreed order under the rule for it to extend that deadline. In the 15th Circuit, we are requiring you to set it for hearing if you're going to extend summary judgment, Daubert, or discovery deadlines, because those things will almost necessarily impact the trial readiness date and the counter call. So you need to have that conversation. Otherwise, upload an agreed order, you're good. If your extension will affect the remaining deadlines, you cannot just seek an extension of the deadline. You must, under the rules, seek an amendment of the DCMO itself, okay? It's nuanced, but it says it right in the rules. So when in doubt, stop, go back to the rule and follow one of those paths. Or you're going to have to file a motion to continue trial, and we're going to talk about that in a second. So if you've got a vacation coming up, this whole theme for today is get ahead of it. Don't wait. And hopefully get an agreed order. If you just can't get the opposing party to respond, we're aware this happens. Put it on UMC. The quickest way to address this is get it on UMC. All right, so here's what the motion, I'm not going to read this verbatim, it's the rule, but motions to extend a deadline, amend the CMO, must contain these items. The most important being number 4, which is the action and specific dates that will enable you to meet the proposed new deadlines. All right, so there's a lot more that have to go into these motions. Make sure when you're asking for these things, you're telling us that you've thought about it. You've thought about the case management plan and how tinkering with this one deadline is or is not going to affect the remainder. And then we say, okay, they've got a plan, they're good, signed. All right. Now, motions to continue trial. Different than a motion for an extension of a deadline. In the 15th Circuit, our DCMO sets a trial. In the rules, you will see reference in a couple of places to projected trial periods and actual trial periods. This matters. The reason why, if a circuit like the 15th sets an actual trial period, to continue the trial, you must file a motion to continue under Rule 1.460. You're no longer moving to just extend a deadline of a projected trial date. Other circuits might have that, so keep that in mind. 15th Circuit, we are setting actual trial periods. The day the case is filed, you're getting your trial period, and it is associated with your calendar call date. So you will have to file a motion under Rule 1.460. And the reason that is also that is important is because I'll show you in a second. It actually comes up later, but Rule 1.460 has a lot more to it that you are going to need to include in your motion. And we are going to have to include findings of fact when we enter an order. So these things are critical to make sure that you're following the 2 different rules for extensions and continuances.
Judge Schulman, just one quick note. I'm sure other judges are going to do this as well, but I'm going to modify my divisional instructions. And what I'm going to suggest to the attorneys is when you file these motions, file it with a proposed order that has your plan and has your proposed findings of facts that justify your continuance or what it is you're trying to do. Make it easy if you can, and show us the plan. We want to work with you. Just make it easy for us. That's it. Well, thank you, Judge Schulman.
Absolutely. The more you can show us you're on top of it, the less we have to monitor. And then with respect to attorneys withdrawing, gone are the days where you can just file it and let it sit. You got to set it for hearing, or better yet, get the client consent in writing, upload a proposed order, tell us that the other side doesn't object, show us your client's consent, upload the proposed order. You don't have to wait for a hearing. We're not going to have time for all these hearings. With everything you all need us to do, we need to help triage for you to save this precious hearing time. So do what you can to get everything done ASAP, get out of the case before the next deadline hits. In your proposed order granting the motion to withdraw, specify whether the deadlines remain set or whether somebody's going to be seeking extensions. But this is something you definitely want to think about Is this the week before a big deadline, a week before a hearing? Is the hearing going forward? Have that conversation with your client. And if it's going forward and they're representing themselves pro se, put that in the proposed order. So it's really just thinking ahead of time and not waiting for that hearing to have that discussion. All right, so, how do we know about this actual trial period, projected trial period? It's in the rule. It's right there. And you'll see E2 is modifying actual trial period. Like I said, you got to seek a continuance under 1.460. Projected is very similar to extending a deadline under 1.200E. When in doubt, go back to that rule. All right, so jumping for a second, I'm leaving rule 1.200, which is our big, huge case management rule, and I'm touching on rule 1.090, which is enlargements of time. This is the recent amendment. You will see at the bottom that they wrote into the generic enlargement of time rule that now extensions of deadlines in case management orders are governed by the case management rule, or 1.201 which is for complex cases. And trial continuances are governed by rule 1.460. So if you're doing a different type of extension or enlargement of time, and by the way, you have to do it before the deadline expires. Don't wait and file a motion, because under this rule, you have to show excusable neglect. There it is. All right, Judge Curley.
Oh, back on. Okay. Judge Schulman and I know what you are all wondering about, and that will have to do with hearing times and how we're going to get hearings and things like that. We're about to jump right into it. Let's talk about a couple things under Rule 1.200, notices of unavailability. They're filed quite often, have been filed quite often. I got a vacation, I've got a wedding, I've got this, I've got that. We get it, but they're no longer valid. Having practiced in federal court, they used to kind of laugh at me when I would say, but Judge, I filed a notice of unavailability. We won't laugh at you, but we can't, it doesn't mean anything anymore. So notices of unavailability, the takeaway there is it's not enough. You have to do more than that. So what should you do? And how do you handle things? Well, let's look at section G, titled Inability to Meet Case Management Deadlines. If any party is unable to meet the deadline set forth in this case management order for any reason, including, see, they know, including due to the unavailability of hearing time, set a case management conference. How do we do that? We're going to talk about that in just a second. And identify the issues that have to be addressed. So what are you all going to need to do? What do we need you to do? First of all, as I mentioned before, if you sense that it's going to be hard to keep up with the deadlines, there's something unique about your case, unique about the people in the case, there's something going on that's going to be a problem for you, don't wait. Set a case management conference. Here's how we're going to do that. You can go to the next slide. Oh yeah, this is our favorite slide. Judge Schulman, this is a great slide. Let's talk about hearing time. So what can you do? Comes up all the time. We know, can't get hearing time. Instead of pushing back. So I told the judges, and I'm telling you guys, instead of pushing back on this, and we're going to need to embrace it. How do we embrace hearing time and making sure that people have enough hearing time and can come to us? Because what we're urging you to do is come talk to the judge about issues with these things before it becomes a blown deadline or something like that. So how do you do that? Here's what we're going to do. If you go to the next slide. Okay. So we're back to DCM conferences and having things heard. What you're going to see, if you aren't seeing it already, as an example, what I do is I have 2 hearing times on Mondays in each month when we have the DCM conferences. I've had it for a little while. Hardly anybody ever comes, but it's available to you, and it's available to set a motion so that we can talk about hearing times or issues with meeting your deadlines and things of that nature. If the judge doesn't have that, then set it on the UMCs and go see them. We're required to deal with it. There is no more, we don't have hearing time, we can't deal with it. What the judges are going to do, and I know this because we talked yesterday, what judges are going to do is they'll change their divisional instructions. This is mine. I don't know if you guys can see all the hen scratching all over it. It's a work in progress. I'm getting there. But this will be out in the next couple weeks with all kinds of stuff and suggestions for you all with respect to things like hearing time. I mentioned continuances and other ways to make it easy to comply so that we can all get on the same page. But we're going to do that.
Judge Curley,
Yes.
what do I do if I can't get hearing time to talk about the fact that I can't get hearing time?
You're going to set a hearing on the DCM conference. And
What if the judge is not, we're all busy and the judge says set a DCM conference, but I don't see any DCM conference time?
Then go see it, the UMC, set a case management conference on the UMC. And that is something that you're required to do. Grumpy, whether the judge is grumpy about it or not, and hopefully they won't be, they'll be like, thank you for bringing that to my attention. That should be the response that you get. And then let's set your hearing time, or let's deal with your deadlines. And you're going to suggest, just like you said to him, Judge Schulman, here's my plan. I have a plan. This is the extension I need. I've talked to opposing counsel, and this is what they either agree with or don't agree with, but here's the plan to get this done and bring it in on time. In addition to what I've told you about, and I don't know if Henry Wolf's on this call or not, but Henry, I promised you I would talk to the judges and make sure we're going to do a survey with the judges. And everybody is gung-ho about that. And even if we weren't gung-ho about that, which we are, the Supreme Court's going to come out soon. I don't know if you guys can see this, but the work group on judicial practices for trial courts is telling us this is coming, that where judges are going to have, like you see in federal court, surveys that will tell you, here's how to get hearing time, here's how I do a bunch of different things, so that you all can just look at our judicial survey and it will tell you how to do the things the way that the court would like them done, so that you won't have to worry about it and you can focus on making sure your client gets the best representation possible and not worried about whether the judge is going to be happy or not with the way you're doing it.
If I can add to that.
Yeah.
From the judge's side, it is in the AO, and we have been talking about this as recent as yesterday. We are required to put in our divisional instructions, as Judge Curley said, how you set these DCM conferences. If we are requiring you to set it on a special DCM docket, we have to manually open that time. So if you're going on there and you're not seeing that time, give some of these judges grace, let their JAs know that there just is not hearing time, DCM hearing time available. It's possible that they didn't open it up for the next month and they just need a gentle reminder. If we're not providing that time, then we need to let you set it on UMC. So we know this is an issue. We're working on it. Give us some time to work through this, but we are really hopeful that in this new year, you're going to see an ability to get in front of us. And that is what we want.
That's our mandate. We have to make it happen, and we will. All right, next slide. So if a trial is not reached during the trial period, okay, this is the new rule on that. The court has to enter an order setting a new trial period. As you can see in the middle there, the court must enter an order setting a new trial period that is as soon as practicable, given the needs of the case and the resources of the court. Here comes the really important part from our perspective and yours. The order resetting the trial period must reflect what further activity will or will not be permitted. Is discovery frozen? Is that it? You should have been ready for the docket you were up on. Why aren't you ready for the next one? So again, my divisional instructions, and I'm sure you're going to see it in a lot. I'm going to have something that deals with this. What I'm going to say is unless you have an order that says otherwise or an agreement that says otherwise, discovery is frozen at that point in time. That'll be it. You should have been ready for the docket before. And if there's an issue with that, you either worked it out with opposing counsel or bring it to the court's attention. How do you do that? Set it for a case management conference. But that will be in divisional instructions and should be fairly uniform going forward. So if your case isn't reached, think about whatever you need to do that you haven't done already. Try to work it out with opposing counsel or bring it to the court's attention. Don't just think, well, I'll take care of it. We're not going to get reached this time. Okay.
All right, somehow we already used up 45 minutes and this goes until 1:30. So we're gonna save at least a half hour for Q&A and then we can stay on, you all can leave, we'll stay on as long as we can to keep answering questions. The bar is going to extend it, but I'm gonna start speeding it up for my slides. So Rule 1.200, it's all right there, the case management conferences. The big points here are that, surprise, you're having a case management conference during your hearing on a motion to strike. That's right in the rule that other hearings are convertible. Keep in mind, if we're going to require you to hear other motions during, or have a CMC during other motions or hear all pending motions during a CMC, we have to give reasonable notice and vice versa. But each hearing, let's talk about your case. Let's get out in front of it. That's when you have opposing counsel on. Any issues you're having scheduling, bring it up. Failure to appear. This is a big change. This is key here, that failure to appear for a case management conference, the court can now sanction by striking the pleadings. It's unclear what they mean by a party, if that means party versus a lawyer or just an opposing party, but that will play out soon. The point is, show up, calendar these things, show up, don't get sanctioned or have your case dismissed for failing to appear for a case management conference. At the end of these, we have to do case management orders, so be prepared to provide those to the court. All right, complex litigation, we're not spending a lot of time on. That's it's been around. The point being now, our AO does tell you, this is a snippet of the AO. It tells you exactly how to redesignate a case to complex. The parties can't just agree it's complex. They have to come before the court. The AO tells you how to do that. And now on to Rule 1.202. We're under a new rule now. This is huge, guys. This is, if you haven't read it, please read it, because we are going to be asking you if you have conferred, and you now have to confer prior to filing your motion. I get it. You hardly can get a response from the other side as it is, but you have to make the effort and you have to put this certificate of conferral in your motion. There are exemptions to that, which we'll show you right here. There's exemptions for a party not represented by counsel. You don't need it for seeking a default, etc. But if that's the case, look at the bottom of this slide. You then have to certify that conferral is not required. So, and you're wondering, when is this in effect? We're going to get to that for all the rules at the end of this presentation, but basically everything's in effect, except for initial disclosures. But conferral prior to filing a motion, January 1st, you should be conferring. All right, summary judgment rule, same thing, it's in effect. So follow this, and here's the reason why. That, sanctions. They've written it into the rule, failure to comply may result in an appropriate sanction. Again, we don't want to do this, please don't make us do this, help us help you. All right, and moving this along, Judge Curley, discovery amendments.
Yeah, quick word on the key discovery amendments. That would be the disclosure rules. You can go to the next slide, even though I like that old slide. Initial discovery disclosures, the scope of discovery, supplementing responses, and the sign. Those are all really, really important amendments that were enacted in May. The duty of initial disclosures within 60 days of service is if the case is filed after January 1st, 2025, that applies. What about the duty to supplement? It applies to old cases and new. You now have a duty to supplement your discovery, old cases and new, folks. So you don't have to reserve the same discovery over and over again to make sure you got everything and that something didn't come in. The duty to supplement now applies. Okay, next slide. All right, the general provisions on discovery, just a couple of key takeaways here. Initial disclosures must be served within 60 days of the complaint without awaiting a discovery request. A party must make its initial discovery disclosures based on information then reasonably available to it. A party, here's a couple key ones for you. A party is not excused from making its initial discovery disclosures because it did not fully investigate the case before it filed it, because it challenges the sufficiency of another party's initial discovery disclosures, or because another party has not made its disclosures. That's right. You have a duty to make your disclosures regardless of what the other side is doing. A party who formally objects to providing certain information is not excused from making all of the other disclosures required by this rule in a timely manner. Even though you made an objection, you still have to produce the rest of it. And discovery doesn't stop just because only part of it is produced. Next slide. Sequence, timing, that first change is a big one, folks. A party may not seek discovery from any source, that means third parties and everybody else, before the party's initial disclosure obligations are satisfied, except when authorized by these rules, stipulation, or court order. So if you need early discovery for some reason, what does that mean? That means you got to either work it out with the other side or come see the court. So you've got to make, in order to get going with your discovery, you have to make your initial discovery disclosures, and you have to certify that your response is compliant. Okay. So let's go to the next one so we don't take too much time there. Here's the scope of discovery, proportionality. I think this is really a helpful thing. Embrace it, don't fight it. It's any non-privileged matter relevant to a claim or defense. That's where you start. It's non-privileged and it's relevant. Then you get to proportional to the needs of the case. And it gives you the factors to consider, considering the importance of the issues at stake, the amount in controversy, many, many factors. I think those are, there's a lot going on there. There's a lot of that you can do. If you make an objection based on proportionality, you have to say why. You have to be specific about it, folks. What this is intended to end is a couple of things. No more deep sea fishing expeditions. They should be over. Things like you've got a simple auto accident case and you ask for 20 years of medical records. You got an employment case, you ask for 20 years of employment history and payroll and things like that. All of that stuff needs to be tailored to the case. Surely that doesn't apply to the Supreme Court's forms. It does. Even the Supreme Court forms now you have to tailor those to the needs of the case. They have to be proportionate. Used to be, argument that I used to make and used to love when people would make it is if it's good enough for the Supreme Court, it's good enough for you, Your Honor. And this guy, well, that may not be true anymore. It has to be proportionate to the needs of the case. Things like tax returns and stuff like that. Can't just ask for it all anymore. It has to make sense. Okay, next. Oh, this is a big one. This requires signing disclosures on discovery requests. Think carefully. The takeaway here for counsel, think carefully about who's going to sign on that these are compliant. Every disclosure and discovery request has to have it. The objections have to be signed by at least one attorney of record. They have to include the attorney or SRR's address, email, and phone number, and the person who's signing it verifies that to the best of the person's knowledge, information and belief formed after a reasonable inquiry. Next. So, signing disclosure to whoever signs needs to be the one who did the inquiry and can be sanctioned for a violation. The rule expressly states at the end, no party has a duty to act on an unsigned disclosure, so they have to be signed. And if a certification violates this rule without substantial justification, the court on motion or its own must impose an appropriate sanction on the signer, the party on whose behalf the signer was acting, or both. The sanction may include an order to pay reasonable expenses, including fees caused by the violation. It's a must for us, not a may. We don't want to be there. We don't want to be involved in these hearings, but the Supreme Court is telling us it's a must. So be careful about that. Make sure the person who signs on these things has the knowledge that can support what was done.
Judge Curley, there's been a couple of questions that have come in as we've had sanctions come up, because that always gets all the practitioners' attention, as it should.
Right.
Has the court been given any guidance beyond the language in the rules about what would constitute an appropriate sanction?
Appropriate is the key there. And what I personally like about appropriate is I read that to mean that judges have some discretion on what an appropriate sanction would be. So we do have a discretion there, and I'm glad that we were left with that. We'll see. For me, I can only speak for me on this one, but for me, I'm going to want to know what the prejudice is by these things. I'm going to want to know a little bit of the detail, and the goal on my part is always designed to mitigate whatever the prejudice, the harm may have been caused by the non-compliance. So I'm always going to look for that. And I think appropriate gives me the ability to limit it to that. But I'm only speaking for myself on that. So I think Binger lives a little bit. Prejudice still matters. Okay, next slide. Okay, this one I like this one. This is really good. Say goodbye to boilerplate objections, folks. The grounds for objecting to an interrogatory must be stated with specificity, including the reasons. Any ground not stated in a timely objection is waived. Any ground, whether that really is supposed to include things like attorney-client privilege and work product, I'm not sure. But I'd be careful. I would reserve those objections the right way if you need to, unless the court for good cause excuses the failure. So this is one in the order implementing the new rules. The Supreme Court wrote this provision was included to avoid discovery objections that just generally cite to an objection, and they specifically mentioned proportionality. That's why I said that when I addressed proportionality. So if you're going to object that the discovery goes beyond the needs of the case, so to speak, you need to have some details as to why. Okay, next. Here we got request for production, pretty much the same thing. They have to state with specificity the grounds for objecting to the request, including the reasons. If an objection is made to part of an item or category, the objection must state with specificity the grounds for objecting, including the reasons, and an objection must state whether any responsive materials are being withheld. I'm so glad to see that. An objection to part of a request must specify the part and permit inspection of the rest. No more holding back a bunch of stuff based on an objection. Whatever is should be produced has to be produced, and whatever you're holding back on the basis of objections, you have to tell them that. Next. Failure to make this discovery more sanctioned stuff. Oh boy, this is the hammer behind it. Oh yes, hammer time. Okay, so can I get past? Yeah, I got to get past hammer time, literally and figuratively. If a party fails to provide information or identify a witness as required by the rule, the party is not allowed to use that information or witness. There's all kinds of stuff here that some of it's pretty draconian, folks. For failure to make appropriate discovery required by Rule 1.208A, that's initial disclosures, etc. Look at that, number 2 there. It can inform the jury of the party's failure to comply. Those are draconian. There's draconian measures here. The Supreme Court is really trying to cut down on discovery violations. So take away, make sure that the discovery is done right. Make sure that the person who certifies the discovery will make a wonderful witness on the efforts that were made, the things that were done, the good faith that was involved. There's a lot of discretion there in number 3, impose other appropriate sanctions. There's just lots of stuff that the Supreme Court is giving trial judges to work with. These are our least favorite hearings, but the Supreme Court's message is clear. How do we avoid that? Let's be compliant. Let's try the cases between the lines.
But fair number of questions coming in on discovery, Judge Curley, which is not surprising. So I'm going to just, before we shift gears, I'll lob a couple of them your way.
Okay.
With respect to Rule 1.340, is there a prohibition in that rule with respect to responding in part and objecting in part?
Well, with respect to that, what I would say is if you're objecting, you need to be specific about your objection, and then what you're responding to, be clear about. This is providing you everything that I didn't object to. So I would say the answer to that is no. There's no prohibition against that, providing your objection specific, as is your provision of discovery.
The certifying as lawyers, is the certification will be sufficient if the certification is simply the attorney's signature, address, email, phone number, what the court typically sees now as a signature block. Will that be sufficient, or does the certification require anything more?
The last part, it's kind of in the way there, but the person has to certify that to the best of the person's knowledge and information and belief. They got to certify that. So that, in other words, they were diligent in their efforts and they're prepared to defend that if called upon to do so.
And does the inadvertent disclosure rule survive? Communication between lawyers and clients inadvertently produced. I would think it would.
I would think it would too. I hope so. I certainly hope so.
I do too.
But let me say this about all this discovery stuff. The prudent thing to do, I would think, is to have a good conversation with your clients and say, okay, this is what we're required to do now. These are certifications we have to make. Get your client on the team so they understand why you're being diligent and persistent with respect to discovery and making sure you got everything that they've got. The worst thing that's going to happen is your client's deposition is taken and they talk all about these documents they never gave you and how important they are. And now what are you going to do? Your client's already said they've got this stuff and makes it look like you didn't do what you're supposed to do. And how you can't really blame it on the client. It's a conundrum that should be avoided. So please do talk with your clients and make sure they understand this is how it works, and so that they don't put you in a difficult spot.
So Ron, I'm looking at the actual rule. I don't think the rule requires you to, this block that's up there now, to put all of that in your signature block, if that's the question. Different for
I believe it
conferral.
is. Yep.
Right, different for conferral, which requires that whole certificate.
Right.
The rule sub K says by signing, an attorney is certifying these things, but that doesn't mean you have to reprint those. So you have to sign it, include your, who you are, and that is what is implied when you sign.
Thank you.
All right. We are in the home stretch here, guys. Judge Curley, do you want somebody jump in? No? Okay.
Your turn. Yeah.
All right. Okay, we're not gonna beat this dead horse, but there is no more at issue rule. Either the wicked witch or the good witch is dead, depending on how you look at it, all right? Is what it is, we've got to accept it. So the rule is very clear, failure of the pleadings to be closed will not preclude the case from being set for trial. Again, we are now issuing trial orders day one. It's an order setting trial. I'm not going to go through this in detail. Just remember, you file a motion to dismiss. You don't set it for hearing or act on it. You're having a trial with that motion pending. And we're just going to say, you'll learn next time. That's what we're being required to do. So make sure you are taking action if you want something heard. Motions to continue. I talked about this earlier, but read this language. I mean, this is, when have we ever seen language like this? Motions to continue or disfavor should rarely be granted. Successive continuance is highly disfavored, and lack of due diligence is not grounds to continue the case. They mean it. They really mean it. And in case you don't know, you may have heard, but they're asking us how old are our cases. And that's because we're required to move cases along and provide prompt justice for people. So all of this is tying in together to serve the public. As I mentioned earlier, motions to continue now have to be very detailed. Read the rule. I'm not going to read this now, but do it as soon as you know you need a continuance. If you're having a baby, you've got several months to file a motion to continue, right? Because of maternity or paternity leave. Don't wait till the last minute. Any issues, just jump on it, get ahead of it. And as I mentioned, the order the order on a motion is going to have to recite the factual basis, either on the record or a written order. So if you're giving us a proposed order, it's in Judge Curley's divisional instructions. It's going to be in mine in about an hour. Make sure you're giving us those findings, okay, so that we can act on your motion promptly. And the order must reflect what further activity will or will not be permitted. Is discovery frozen? Does everybody agree to open up discovery, etc.? Think about these things, make sure you address them. All right, summary judgment, you know, these are just deadlines now. The bottom line being, we have now calendared in our DCMOs and trial orders the deadline to file a summary judgment motion, which accounts for the fact that a response is now due no later than 40 days after service of the motion. These are no longer tied to the hearing date. So you have to file it. I would suggest setting it immediately for hearing. What you do is you calculate 40 days out for response deadline, and then per this rule, at least 10 days for a hearing to occur after that. So 50 days out, you can be setting your hearing now for 50 days out. Our DCMO trial orders calculate this for you. The left-hand side is what our internal bot, what our system does is for circuit, this is for circuit only, 80 days before counter call, you've got to file your motion. I mean, yeah, that's a lot sooner than counter call, but we are allowing you to get that 40-day response deadline, the 10 days for the hearing, 10 days for reality. The right-hand side here is what your DCM actually looks like. Those dates are calculated for you. You just have to plop them in your counter or your assistant. So we've also calculated completing discovery prior to those motions being due, recognizing that it can't be after the fact. And that's completion of summary judgment discovery. Completion of all discovery is also calculated for you. Okay, and we know we have a lot of questions on the effective dates of the rules. And by the way, this is rule 1.820, just be aware of it, please, about arbitration decisions. So when do the new rules take effect? Well, they're already in effect. January 1, some of them were long before that. The bottom line, and I'm going to skip to the next slide in a second, which summarizes it differently, but the bottom line is initial disclosures do not apply to cases filed before January 1. All other amendments, including the duty to supplement, do. That includes motions for extension. That includes summary judgment motions. The motion has to be filed on or after January 1st. So you're really not looking at the date of the case filing, except for initial disclosures. Everything else is looking at the date of your filing of your motion. Same thing with conferring. As of January 1st, you need to be conferring prior to filing your motion. If you already have a DCM in place prior to January 1st, those deadlines govern, but any extensions are governed by the new rules. We get it. This is awkward. It's going to be awkward for about a year to 18 months until, pending cases get resolved. We're just going to have to work our way through it. This is what we've been given. So to summarize, initial disclosures, no. All other amendments, yes. Extensions, amended rules, motions, new rules, and affirmative defense has already went into effect July 1st of last year, which now seems like an eternity ago. All right, that, Judge Curley, is the end.
Quick note. So what you can expect from the judges, we'll get to judicial surveys soon. So we'll get out to you how our hearing time works, how our other practices work, and we'll make that easy to find. So make sure that you're looking at that. It'll address things like rollovers and divisional rules. The one thing we didn't mention today, but we will, we do know that in certain instances, we can rule on the papers. So if you all have matters where you would prefer the judge just submit your papers and let us know, but I'm going to put that in my divisional rules as well, that we're available and would love to do that when we can. Why? Because it saves hearing time for things where you need it. Anything we can do to save hearing time for the things where you really need the hearing time, we're trying to do that.
Judge Curley, that was one of the questions. So if you don't mind, I'll jump in here.
Sure.
What kinds, I know a lot of the judges are trying to offer that to the litigants. And are there some motions that some judges will just say they are going to decide those motions on the papers?
Well,
For
I can only
example,
speak-
motion to dismiss.
Yeah, I can only speak for myself, and I haven't categorically done that. I usually wait for the parties to let me know if that's what they'd like me to do. I'm happy to do it on virtually any non-evidentiary matter. Sometimes I need to hear from the attorneys. The papers, just for one reason or another, I'm not sure I've got everything that I need, but I can always say, I've read your papers, love to rule on the papers, but I need to set a 10-minute hearing with you guys so you can answer a couple questions for me.
And the other question was logistically, how should that be done? In other words, when filing a motion, should the parties just do an email to the court and say the matter is fully briefed and we agree that you rule on the papers? Or what is the best way to logistically let the court know that the parties have agreed to let this be decided on the papers?
For me, cover a letter and send it to Lucille, that's my JA, with a copy of the papers and that the parties have agreed that the court can rule on this without a hearing. The thing
I
that
think
would
this is
ask
the new
them to do-
wave. I'm sorry.
No, this will be real quick, Judge Schulman. The thing I would ask them to do is call Lucille and let her know that it's coming so that she will get on top of that right away and get it to me. So most of the time it's for expediency, I would think. So if they can get that to me right away, and if there's a reason why I can't get right to it, I'm in the middle of a 3-week med mal case or something like that, I'll let them know. Go ahead, Judge Schulman. I'm done.
I think this is the new wave. There's talk at the Supreme Court level about, addressing these things, hearing time. How can we rule on the papers to help the parties get their matters? When we say heard, that doesn't necessarily mean orally in open court, but ruled upon, heard on the papers or otherwise. A couple of us have standing orders on this, which tells you how to do it. For those that don't have standing orders, this is a work in progress. We need to keep having these conversations, but as Judge Curley said, let the judge know this is something you're interested in. And perhaps, if there's not divisional instructions on it yet or a standing order, upload your proposed orders with those cover letters and say, these are competing orders, make sure you're clear. But we're asking the judge to take a look at this, or set a UMC to just notify the judge that it's out there. But these are all creative ways that, hey, try something, try it. We start to adopt things that the attorneys do and that we like, and we say, that's a great idea. I'm going to implement that going forward.
We have some questions about initial disclosures and thoughts on how the landscape of cases will change. So I'll start with one of them and then it'll probably segue nicely into the next one. If a case is not tried on the original setting, does the duty to supplement discovery continue forward? So we didn't get reached on the first trial setting. Do the attorney still have a duty to supplement? Discovery deadline's closed, obviously, but we're getting set on a later setting. Do we have any guidance from the court on how that might play out?
Well, there's a practical side to it. Like my divisional rules are going to say that unless I have an order otherwise, discovery's over. So that to me would suggest that duty to supplement's over as well. On the other hand, if you've got new stuff and it's not on your exhibit list and you haven't disclosed it, you're probably not going to be able to use it. Right. So that would be time to come in with a quick motion saying we found something and we couldn't find it before, and we'll talk about it.
Okay. And then impeachment discovery or impeachment evidence. So the question is, often in bodily injury cases, the fact of prior treatment, example, the current complaints, is not revealed by the defense, save for impeachment. But now with the pre-trial or initial disclosures, it has that ability to withhold that information solely for purposes of impeachment changed? And do parties now have a duty to disclose that information as part of their initial disclosures? Do we have any thoughts on that?
Yeah, I can't remember the exact quote from the disclosures, but I would say if it calls for it, you better do it. Or risk not being able to use it. But I don't think it says impeachment, does it?
I don't believe it does, but
No.
we're all learning.
Yeah, us included. That's a great question. That one for sure will be tested by somebody who's a risk taker.
Judge,
Okay.
we have a few questions, that can kind of be wrapped up. Some of the amendments specifically say that the scope of the rule, look to the federal rules, like this is intended to mirror the federal rules. Some don't. Should the general approach be to construe these rules closely with what the federal rules require?
Judge Schulman, what do you think?
I think with respect to discovery, proportionality, supplementing these types of things that were drawn from the federal rules, absolutely. It's always the case where if there's binding case law in state case law, we go with that first. In the absence of that, absolutely bring it to our attention. We're federalizing in a way our rules. So if it says it, then absolutely bring the federal case to our attention. And even if it doesn't, but it's you know that this is a rule modeled after the federal rules, I would strongly encourage it. It may not be binding, but it's persuasive.
Yeah, they didn't limit it. I know in the footnotes, they didn't say like federal law from South Florida or Florida. There's no limit. They did for the discovery changes, proportionality refers back to the federal case law in the footnotes. So for that, for sure, we're looking at federal law. And I wish they'd limit. I wish there was some limits because I think you'll be able to find a lot of support for positions.
Conferrals. Fair number of questions about meet and confer. So I'll wrap some of these together. And there's an interesting question about our local Rule 4 and how the new conferral rule, and how our local Rule 4, the conferral before setting a hearing, how those two intersect or maybe don't intersect. So one question that's come up is what is a sufficient conferral? But along those same lines, and I think more helpful or as helpful, is how is the duty to confer pre-filing of a motion? How does that change, if at all, our local Rule 4 requirement that we meet and confer before setting the motion? Is it reasonable to assume that if we have met the rule, the new rule in terms of conferral before we file the motion, that we can certify that we have satisfied Rule 4 as well? It would seem that we would be able to, but the questions come up. What are the thoughts from the judges?
Schulman?
Sure. So I think, and that's a great question. Local Rule 4 is absolutely still in effect. Now, I'm just speaking for me. I think if you are talking to each other before filing the motion, that also comes before setting it for hearing. So I think, yes, especially if you've had a meaningful conversation. If it's, I tried to reach out 5 seconds before I hit e-file and they didn't answer my call. And so I tried, but didn't get anywhere before filing. I think you should make another attempt before you set it for hearing. So now you're really either accomplishing that conferral or you've made 2 attempts. So look at it that way. The point is the Supreme Court, we want you to be talking, keeping in mind, we understand you don't always get a return call. But tell us tell us. And then when we start the hearing just this week, I said, all right, you didn't talk. the new rules in effect. Let me put you in a breakout room, talk now. And they came back with an agreed order. But if somebody's not responding to calls, now they're gonna be in violation of the.
I always think that it looks good when it looks better for both sides when they've spoken and tried to resolve something, or they've reduced the issues. They almost always reduce the issues when they have a genuine effort to try and resolve it. On the other hand, it doesn't look good for someone who isn't returning phone calls and isn't talking, and if the movement hasn't made the effort, we're not looking for ways to deny motions, but that's the easiest denial you'll ever see. They didn't make any effort to talk. They just ran in, and it's something they could have talked about. They're either going to be sent back out to talk, or the motion is going to be denied without prejudice. And after you have a conversation and after you try and work through the issues, because the judges want the attorneys to get along and have a good dialogue. Personally, I've never understood not getting along with opposing counsel, but we want you all to get along and have those conversations and try and work through the issues so that, again, you're focusing your time and your clients' money on the things that really matter and not the bickering.
So the new rule, and no matter how many times I read this, and I'm now up to 100, under the sanctions provision, the last part, this is sub D, says the purposeful evasion of communication under this rule may result in appropriate sanction. So the Rules Committee, the Supreme Court, I think, recognized the problem with people returning calls. So let us know.
Ron, I know you have a lot of questions to get through, but the bar has asked us to announce that the PowerPoint will be emailed to everyone who is registered, and that the CLE number is 241-4017N.
Thanks, Bridget. What we included, can I say this about that? What we included on the first PowerPoint were the actual red lines. Don't think they're attached to this one. So there's only a few changes that occurred after the first go round. As Judge Schulman mentioned, the best thing you can do is look at the red line version, so you'll see the exact changes that were made. And some of those changes that are made, it'll be evident to you what the message is that the takeaway that they want you to get.
Another question that we received is, and this is common for busy practitioners, is when you're set on multiple dockets, trial dockets. And the question comes in, understanding that notices of unavailability are no longer useful, should we still be filing notices of trial conflict? How can we address being on multiple dockets with no set dates and a little ability to move trial dates? Well, I think set dates will have a better understanding of that from what will come out from the court in terms of the order. But I think the question is if you're sitting on multiple dockets, how do we communicate to the court that conflict, and what flexibility, if any, does the court have to appreciate that reality for a busy trial practitioner?
Well, part of the message that we got from the rule changes is that we can pick up the phone and call other judges to try and coordinate things. Not to make life more difficult for busy trial lawyers, but to try and make it a little more manageable. I think that's just part of the process. You're going to have to try and coordinate that. It's personally, if you come to a docket call and you say, I've got a trial in front of Judge Schulman and it's scheduled for such and such, we're going to accommodate that. But the first filed trial usually takes precedent. To the extent that helps. I don't know. Judge Schulman, suggestions?
Ron, I've gotten a number of emails about repeating the number, the CLE number. 2414017N. Thanks.
Motions for extension of time under Rule 1.090. is it sufficient to file the motion before the time frame expires, or are practitioners or parties now required to have the motion resolved before the deadline expires?
Great questions. I think the motion, I'm looking at the rule. If the request is made, so the court may for good cause extend the time. If the request is made before the original time expires. But keep in mind, don't file your motion for extension and then not do anything about it. But if you get to that last day and something came up, you had an emergency, at least file the motion, and then as soon as your emergency resolves, number one, try to get an agreed order, and before you file it, do that, but address it. So you've got a little wiggle room, but you can't let it sit.
And on cases that don't get tried on the docket they're originally set on, do we have any guidance in terms, does the court, do you all judges have any guidance in terms of what you will look to in terms of the resetting? Is it just going to be like it has been, where we just roll it over to the next docket? Or is there any indication on how new cases that don't get reached will be set on later dockets?
Me, that'll be in my divisional instructions. It won't automatically roll over to the next docket. So it'll either be set or I'll set a case management conference. More likely than not, I'll just have a case management conference, which I've done before. Everybody who wasn't reached, case management conferences, discussion of resetting their trial, and off you go. But I'll put that in my divisional instructions, and I think a lot of other judges will. That's our suggestion, Judge Schulman and I, to other judges, to put in what their process will be for cases that are not reached, so that the attorneys, for me as an example, ask for a case management conference if it isn't automatically done. And other judges some will just roll it over, I imagine, automatically, but the attorneys will know what to expect.
And following a theme that we've talked about today, Judge Curley, is the case management conference going before a judge on UMC a good, because we've had a lot of questions that have come along around the same general topic. Is that a good mechanism for when, because of scheduling deadlines, we can't get before the court, we can't get hearings set? Is that going to be a good resource for the practitioners to set a case management and just come before the court on UMC and talk about whatever challenges they're having, scheduling or otherwise?
For me, it is. I have no problem. It happens all the time. I probably had 4 or 5 of those this week where people needed summary judgment hearing time, and it's pretty easy. I have in my back pocket hearing times so that when people come in, I can set it. And both sides will tell me, and I'll go, okay, fine, here you go. And I'm happy to do it. Judge Schulman?
I'll add that it's now in the rule that's what they should do. It's in our AO 3.110. And it's in the DCM orders. So this is not just rules, this is encouragement, this is outreach. Come talk to us. And something I do want to mention, I do recognize, we all recognize that divisional instructions are not consistent. Some are, very detailed, some not so much. There is also a movement towards making those either more consistent or at least having a minimum amount of information on a minimum set of topics. So these are all things that the Supreme Court, the rules committees, the judges are hearing loud and clear. I think we're going to have a lot of positive progress on that in the future.
We know we got work to do. We get that.
And we've run through all the questions. So one final question, Judge Schulman and Judge Curley. As we continue to grow, we, the bar and the bench, together through this new error in the state of Florida, practice of law. What is there a good point of contact with the court as practitioners sort of brainstorm about these things to push questions to the court? Do we have that person or persons or email address or somewhere that as we brainstorm these things, we can push them out to you all and continue to collaborate on how to move through this phase in our profession?
He just volunteered himself, didn't he?
Yeah, I think he did.
I
Judge-
think
did-
if I could jump in here, I think that the Judicial Relations Committee and the Civil Practice Committee, the judges attend, they participate vigorously, very strongly. I think, to become more involved in the Bar Association and in the committees, the judges are just, always there for us.
Well, I appreciate that. I was going to ask Iran if Chief Judge put you up to that question or not, because he's got a committee. He wants us to put together a committee for just that purpose. So
I think we would all, and the bench and the bar would benefit profoundly from having that opportunity to have a committee to have that dialogue.
well, it's going to happen. So folks who want to participate, Judicial Relations Committee, I assume it'll come out of that, Bridget, but that will happen soon. That's a work in progress.
Okay, well, we're done with our questions. So
Thank you,
Judge
guys.
Schulman, Judge Curley, Palm Beach County Bar, Michelle, Bridget, everyone who attended. I know that I've taken a tremendous amount of information from this, and thank you all. And we'll continue the discussion as we move forward as a bench and a bar.
All right. Thank you, everybody.
Thank you for having us.
Thank you all.
Bye now.
Bye.